Don't send your child off to college without two essential documents. So, time for your college child to begin their college adventure. Perhaps you bought them a new computer. I remember when my one daughter went off to college, bought her what I thought was a really state-of-the-art computer. It was one of the original Macs. It was one of those really colorful ones that they came out with. And she took it to Purdue and found out that it wouldn't run on the Purdue network because the Purdue network was only designed for Windows machines. I think most colleges have gotten over that. But you buy them a new computer, you pack their clothes, you probably make sure that they have a current health insurance card. I know we always did. Why? Just in case. You hope they won't need it, but you want to make sure just in case because accidents do happen, and you send them off to college. Well, what if that accident does happen? You're probably going to get a phone call. Maybe a call is going to tell you that your child's been in a serious accident and they're in the hospital. And what are you going to do when you get that call? I know if you're like most parents, you're going to get to the hospital as soon as you possibly can. But what if when you get to the hospital, you're told that the hospital cannot provide you any information about your child, you can't participate in medical decisions, you can see your child, but no one's going to share any medical information with you? Or perhaps important decisions now need to be made about your child's care, but the hospital is looking at you and saying, I'm sorry, you can't make them. Why is that the case? Well, what we forget about is that parents don't have any legal authority to make medical decisions for a child once they turn 18. Just because you're the parent. We're used to making those decisions during their lifetime. We're used to taking them to the doctors and having them, if they get hurt, take them to the hospital and have broken arms mended, all those kinds of things. But when they turn 18, in the eyes of the law, they are now adults, and you no longer have legal authority to make medical decisions for them just because you are their parent. The only one with legal authority to make medical decisions for an adult child, if they can't make them themselves, are, one, a guardian. A guardian is going to be somebody who gets appointed by the probate court. So it's going to require a hearing. Someone's going to have to go to probate. Someone's likely going to hire a lawyer because you're not going to know what you're doing yourself. That's going to cost you money. In the end, the guardian that the probate court appoints might not even be the person that you would necessarily want to be appointed because it's the probate court who's going to appoint that person. Although, in all likelihood, if you're the parent, you're going to be at the top of the list to be appointed, but it takes time and it costs money and you have to go to probate court. But once a guardian is appointed, now the guardian will have legal authority to make medical decisions. The other person, though, that would have the authority to make medical decisions in that situation would be a patient advocate. A patient advocate who has been named by your child in a power of attorney for health care. That patient advocate, that authority of that patient advocate becomes immediately effective when the child cannot communicate with his or her doctor about medical care. Essentially, what it does is it takes and it puts somebody in the child's shoes to make decisions that they could make. You don't have to go to the probate court. You don't have to hire a lawyer at that time and spend a lot of money. You don't have to have a hearing. All that needs to be done is that a patient advocate has been named in a power of attorney. That power of attorney, then, is one of the two essential documents that you should make sure your adult child has when they go off to college. Because if you have that power of attorney, if you are named the patient advocate, then when you appear at the hospital, they will share information with you. When you are at the hospital, you will be able to participate in making the medical decisions for your child. It's essential, because all the planning that we do, again, we make sure that they've got a medical card if things happen, but we also want to make sure that they have in place an appropriate power of attorney for health care that will give, if they want to, you, your parents, authority to know what's going on and to be making decisions for them. And while you're at it, there's really a second thing that we should think about, perhaps in some cases, maybe not as essential as the health care, but you should also consider having a durable power of attorney for finances. Again, just because you're the parent, you don't have any legal authority to manage what your child owns once they turn 18. The only one, if they become incapacitated, if they can't pay their bills, if they can't buy books for school or do tuition or do all the banking kinds of things that they do, who then has legal authority? Well, again, one can go to the probate court and have a conservator appointed. That's going to be somebody that's appointed by the probate court. You're going to have to hire a lawyer. You're going to have to go to probate. It takes time. You're going to have a hearing. And in the end, the court might not appoint somebody that you would have wanted to even be the conservator. Although, as I said before, just like the guardian, you're likely at the top of the list for who is in line to be appointed, but it will be entirely up to the probate court. So one way to do it is run off to probate and deal with it then. The alternative is if your child has named an agent, or what's sometimes called an attorney in fact, in a durable power of attorney for finances, a legal document that your child can have prepared, that your child can sign, and then that person under that durable power of attorney can have the legal authority to manage whatever financial affairs need to be attended to for your child. The second document then that your child should have, that they should not go to college without, is going to be that durable power of attorney for finances. Again, if you're sending your child off to college and you want to be sure that everything is in place for them, don't send your child off to college without that power of attorney for health care and a durable power of attorney for finances. Those are the two documents every child should have when they go off to college. Of course, if we can be any of assistance to you, Amanda and I, in putting together the power of attorney for health care and the durable power of attorney for finances, contact us, 517-323-7366. We have clients who contact us this year and say, hey, Tom, my child's already off at school. Can I get this done? In all likelihood, we can. We can work through the internet, email, telephone consultations, etc., so that we can prepare appropriate documentation for your child to sign to get that put in place for them. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.